I'm going to start this and I'm going to play. Well, that was a beautiful video. I thought that was really great as to how well it described all the services it provides. And next, we're going to hear from our gold sponsor, MetaVest. Hold on one second.
Does your case have any outstanding medical?
Hold on one second. Bear with me. I'm still working on this. Okay. Now, we're going to start with this one. And we're going to share a screen. I'm going to make this bigger. And now we're going to play. So this is our friends at MetaVest.
Case have any outstanding medical bills or claims for reimbursement by a lien holder? Are you looking to maximize the settlement funds for your client? At MetaVest, we're here to help. We offer a wide variety of lien investigation and resolution services to help protect the settlement funds. We specialize in Medicare, Medicare Advantage, Medicaid, VA and TRICARE, FEBA, ERISA, hospital, and private healthcare liens. MetaVest has the knowledge and experience to navigate the complexities of lien resolution. Your time is valuable. Let us help you make the most of it. We offer free case consultations, so please don't hesitate to contact me directly at 949-632-0029 or via email at cpauley@metavest.com.
Okay, so now I'm going to turn it over to Karen Cohn, who is going to moderate today's program, and I will let her introduce our speaker. Take it away.
Thank you, Mary. Hello, everyone. It's my pleasure to introduce Irwin Weiss today. And Irwin has been practicing law since 1978. He's been a solo practitioner since 1985. He does mediations and arbitrations, and he shared with me that he's handled over 200 arbitrations. His balanced approach to the law and his fairness make him an arbitrator that both plaintiffs and defendants can agree upon. He was born here in Washington, D.C., and he shared a fun fact with me that he attended the last Washington Senators baseball game at RFK Stadium, September 30th, 1971. And in that game, the Senators had to forfeit it in the 9th inning because several fans stormed the field and ran the bases and pulled up turf and dirt, which must have been quite a sight to see. So without further delay, I'm going to turn it over to Irwin.
Thank you very much. I was not one of the people who ran onto the field. I was sitting in the upper deck in left field, and had I tried to run onto the field, I would have died and you wouldn't be seeing me today. But I am Irwin Weiss. I'm not a member of the DC Bar, although I did try a case in something called the Superior Court about 37 years ago. It was a medical malpractice case. The trial was only about 3.5 days. We started on a Tuesday, went to the jury Friday morning. The jury deliberated 2.5 days, almost 3 days. I spent all that time in the cafeteria. And we did get a good verdict in the case. I represented a plaintiff, but I was never quite able to figure out why it's called the Superior Court. I couldn't identify anything particularly superior about it. But I think with regard to arbitrations, since it's more or less informal, and since you make the rules, and we'll be talking about that in a moment, with your opponent, it doesn't make any difference if you're in DC or Maryland or Saskatchewan or someplace else. You make the rules. There is a statute in Washington, D.C., Chapter 44, Title 16 of the D.C. Code, and Maryland has a statute on arbitration also, Courts and Judicial Proceedings, Article 3-201. I don't think either of those statutes really has a heck of a lot to do with anything that I do as an arbiter. They do provide for relief if you should have an arbitration and let's say the other side refuses to pay. They're worth looking at, but in general, you're going to agree with the other side on rules of arbitration. Now, I only arbitrate tort cases because that's all I know about. I don't do bankruptcies and commercial cases, and I don't do divorce cases and family law, and I don't do criminal cases. All of these cases, except maybe criminal cases, could be the subject of arbitration. There's no reason why you couldn't arbitrate a family law case. But I'm going to be directing my attention solely to tort cases, most of which arise from motor vehicle accidents. Why does an insurance carrier agree or desire to go to arbitration? By the way, you should all have received over the email a short packet from me or a short document from me called Arbitration of Tort Cases and also a sample arbitration agreement. But back to that question, why does a carrier do this? I'm not a mind reader, and insurance carriers don't really have minds. They have high-level personnel who direct their low-level personnel to do all kinds of crazy things, and the low-level personnel just carry out the wishes of whoever's above them. So from time to time, insurance carriers will say, we've got too many cases. We have too many open cases. We got to get rid of some of these open cases. And I think this is particularly true in the era of Zoom. There may be some tax reasons why insurance companies want to get cases off the books. I don't know about DC. I assume it's the same. Civil jury trials in Maryland have ground to a halt. There hasn't been one since March. This is July. There isn't going to be one in most jurisdictions until sometime in the fall. They're talking about having them maybe in October. So far, that's talk. I'll believe it when I see it. It's a challenge to get 100 people or so in a room with masks, jurors to be picked. I just don't think the public is going to be all that interested in participating in that. And if we have a second wave, what's called a second wave, then we may not have a jury trial till 2021. That wouldn't actually surprise me. So carriers have caseloads. They've got all these cases. And when I used to work for several carriers, sometimes they would call me. An adjuster or a claims manager would call me and say, we have too many cases. We're getting an audit from the home office. We got too many open cases. What can you settle? I would say, well, give me enough authority. I can settle all the cases that I have. So that's one motivation for carriers. In the old days, like early 80s, insurance companies kept money in the bank. Money markets paid 14, 15, 16% interest. Now you get no money for a money market or a savings account. And so there is no real big advantage to insurance carriers in keeping the money in the bank. Insurance companies want to limit their exposure. And if you have a case which conceivably could go for more than the policy, you've got a $100,000 policy. If everything goes right, maybe you get more than 100. The carrier's a little worried about that. They may be interested in arbitrating the case with a cap of $100,000 as the maximum they would have to pay. Sometimes carriers won't tell you this, but sometimes they've lost their insured and they're going to have an empty chair, and they don't want that. They think a jury might think that the defendant doesn't care about the result any more than he cared about the way he was driving on the date of the occurrence. And so they may say, we're not going to have this guy at the trial table. Maybe we should go to arbitration. So there may be other motivating factors as well, which cause an insurance carrier to want to do that. What are your motivating factors? Why would you want to go to arbitration? Well, it's less expensive. You may have a case where you got 6 or 7 expert witnesses. You go to arbitration, you're going to put their medical records into evidence, and you don't have to pay 6 or 7 doctors either to be there in court or to be videotaped. Arbitration is quicker. You get a date. Trial dates are notorious for being continued and postponed for all sorts of different reasons. Arbitration is more certain. There's usually a high and a low. You're going to get something. You're not going to have a zero verdict, which plaintiffs get from time to time when the jury just doesn't like the plaintiff. And also there's no appeal. Behind me on this wall are Maryland appellate reports. Those are cases, as you know, where someone didn't like what happened below and they took an appeal. And the case dragged on for a year, year and a half. And some of those cases get remanded. And now the case can drag on for another year and a half. That may be something which appeals to your client, no pun intended, to get the case over with. Their accident was in 2016. It's 2020. You filed suit. Now the courts are closed till 2021. The case may last till 2023. They would like to get their money. You would like to get your fee. So that's a motivating factor. Arbitration is easier to schedule. You don't have to worry about the rest of the trial calendar and the rest of the judges. You get 3 or 4 people together and you can do your arbitration. Another reason why arbitration is favorable to plaintiffs, or plaintiffs may want to do arbitration, is an arbitrator, at least this is me speaking, I think an arbitrator is less likely to care about what you might think are warts in the case. Like your client has a 13-year-old conviction for theft. It's going to be admissible into evidence. Personally, I don't care about that. A jury might not like that. Your client has citizenship issues. I don't care about that. None of my grandparents were born in the United States. My father wasn't born in the United States. The Weiss family was able to come because a man in New York signed an affidavit claiming to be a relative of ours when he was not. So because of that perjurious affidavit, the Weiss family was allowed to come from Europe to the United States. I don't have any problem with citizenship issues, and perjury, I have a soft spot in my heart for perjury. I don't care that much about claims history. The plaintiff had 3 or 4 or 5 prior claims that might be admissible into evidence. What do I care about that? The question is this particular case legitimate? The plaintiff has a psychiatric treatment history. You know, a jury might not like that, or they might question, or they might not understand it. I don't really care about it. My agenda is what happened in this case, and you can think of some other things. You know, I'll from time to time, I'll have a claimant who comes to me and they've got, you know, a nose ring and piercings and all kinds of tattoos. And I'm not personally fond of that, but it has nothing to do with whether they were liable or whether they were injured. Maybe a jury would not like that, or maybe a jury would like that. I don't know. But you don't need to worry about those kinds of extraneous factors when you have an arbitration. Now, there's a downside to arbitration, and I should point that out. It eliminates the chance of an excess verdict. It eliminates the threat of an excess verdict. It eliminates the chance of a runaway verdict. From time to time, there'll be a case which you and I might say, well, this is a $20,000 case, this is a $30,000 case, and the plaintiff, because he's in a favorable venue and there are significant property damage, the client is a wonderful person, the defendant is evil, there's a large policy, maybe that's not a good case to go to arbitration. You've got a chance to hit a home run. Now, Babe Ruth was the greatest home run hitter in the history of baseball. He had 1 home run every 11 at-bats, and in the other 10 at-bats, he did not. So home runs do exist. You can try a case and hit a home run, but it doesn't happen that often. And if your client is a really sympathetic person, for one reason or another, and you get a difficult causal connection issue, you have a very weak expert, and it's a very tough causal connection issue. Maybe you do better with a jury than an arbiter. Maybe a jury, maybe even though the judge tells the jury not to be sympathetic, maybe they're still sympathetic enough to overcome the causal connection issue. But anyway, I'm going to stop at this moment and inquire, are there any questions that I need to address before we move on to the next items? I don't see any questions on the Q&A little button, so I shall keep going. All right, so you've decided to arbitrate. You'd like to arbitrate. First thing I would tell you is you got to make sure it's okay with your client. I mean, we are representing clients, are we not? And some clients will, about 1 or 2%, I think, will say, I don't want to go to arbitration. I think the fix will be in. There'll be some arbiter who knows the other side. I want an independent jury. I want a judge. Well, you can't agree on arbitration unless your client's going to agree on arbitration. You can tell the client why it's a good idea. You can make recommendations, but it's the client's case. The client usually has one case. You got a bunch of cases. We're spear chuckers. We're agents. The client is the principal. So you got to make sure that the client is on board with arbitration. Well, let's say the client is on board with arbitration. You have to raise that question with the other side. How do you get the other side to talk about it? You call them up and you ask, are you interested in arbitrating this case? Get it off the books, move the case. I've done cases now for involving, probably 15 or 18 insurance companies, all the big ones, Allstate and State Farm and Progressive and Erie and Liberty Mutual and Travelers and Nationwide and, all sorts of others. They're all amenable to it if it's the right case. You have to make sure you have an agreement with the other side as to what's being arbitrated. Are you arbitrating liability and damages, or just liability, or just damages? And you got to make sure your client signs off on that. And I had a case the other day where we had a three-way call, myself and the two lawyers, about a week before the arbitration, or 4 days before the arbitration, to go over something. And the plaintiff's lawyer said to the defense lawyer, now, Joe, this is just damages, right? And Joe, the defense lawyer, says, oh, no, we're trying liability also. So you got to know what you're arbitrating. Most arbitrations that I have had come with a high-low agreement. You don't tell the arbiter what the high-low agreement is. You just make the agreement with the other side, and you confirm it in writing. And you agree something like this: no matter what this crazy arbiter does, the least amount of money the plaintiff is going to get is $20,000. And no matter what this crazy arbiter does, the most amount of money the plaintiff is going to get is, let's say, $100,000. The carrier is protected from the runaway verdict. And let's say they got a $100,000 policy, they don't have to worry about an excess verdict. And you're protected against a really low result. When I have represented plaintiffs in arbitrations, I usually don't care so much what the low is, because very rarely, almost never, will an arbiter give a plaintiff zero like a jury might. I've defended a case where a woman was rear-ended by my client in the Baltimore Harbor Tunnel. We blew the car away. The car was just a mess of metal. She was taken by ambulance to the hospital. She was seen in the emergency room. She was treated and released, and then she had some follow-up care thereafter, and the jury came back with zero. It was ridiculous, but the juries do that periodically. So if you're going to have a high and a low, you protect yourself and you protect your client against that type of eventuality. But I don't usually care too much what the low is. And when I propose a high to the carrier and I say, why don't we do a high of $115,000? Let's say they got a 250 policy. And they say, oh, no, we won't put a high of that much on it. We'll do a high of 75, but we won't do 115. I will say to them, well, the reason you're telling me that is because you think this case might be worth 115. If you don't think it's worth 115, what do you care? What do you care what the high is? That argument doesn't seem to work too often, but you want to get as high a high as you can. And I suppose you want to get as high a low as you can. You need to confirm the high-low in writing or by email or something with the other side. And I would recommend that you also have your clients sign off on the high and the low. Wouldn't it be embarrassing if you agree, and you may talk to the client about it. The client may not remember. You've talked to your client, you've talked to the other side, you've got a high of 100. The arbiter doesn't know that. He comes back with 125, and the plaintiff wants to know, your client wants to know, how come I'm not getting 125? Take a page out of the books of our medical friends and do it an informed consent form with your client, where the client signs off and says, I understand that the most I can get is X and the least I can get is Y. Um, and uh, and then you don't have that embarrassing conversation later on. I think the medical people say that 80% of what they tell the people in their informed consent talks, these are the complications, these are the risks, these are the alternatives, this is what the post-operative care is going to be like. 80% of that stuff is forgotten by the plaintiff patient within 20 minutes of when the doctor tells them. So they have them sign something, and we can take a page out of their books and do likewise. Now, there really are no rules at arbitration unless you make them, and I would recommend that you make them. Are you going to permit not just medical records and bills to come in without a testimonial sponsor, but also are you going to permit medical literature to come in? How about a nice drawing from our friends at Amicus? Will you be allowed to use a chart or a drawing or a video? And usually you've got your doctor on the witness stand in trial, and the doctor says this is a fair and accurate representation of what the patient's spine looks like. And this procedure, which you're seeing, this videotape of a discectomy, is what I did on the patient. But you're not going to have a doctor there. Although you might have a doctor there, because there are no rules. You can specify with the other side, I'm calling my doctor, or both sides should have the right to call a live witness. I think what you don't want to have, you don't want to show up for the arbitration and then have some dispute about what you've agreed upon and then lose the date and lose the agreement. So one of the documents which I sent that Mary should have emailed to you, I'm sure she did, is a sample arbitration agreement that I drew up in about 5 minutes, discussing what the rules are, how it's to be handled, what's admissible, what's to be arbitrated, who's paying the costs. Let's suppose you have a plaintiff and you got two different defendants. The plaintiff is a passenger in vehicle number 1, and the operators of vehicle 1 and 2 are both defendants, and you're going to go to arbitration. Who's paying the costs? If you say we're going to split the costs, what does that mean? Does that mean the plaintiff pays half and the defendants pay half jointly? Or does it mean a third, a third, a third? Specify it ahead of time. There's also some lawyers who will do this, and some carriers will agree on this. You've agreed on a low of $50,000 and a high of $100,000. The least they're going to pay you is $50,000. The arbitration is set for 2 months from now. Why shouldn't they just pay you the $50,000 now, the low? If the verdict is greater than 50, let's say it's 62, there'll be another 12,000 later. But why not pay at the time of the, or within a few days or a week following making the agreement? So those are some concepts that I have in the sample arbitration agreement, which you all should have received. Now, here you go. It's time for the arbitration. Before we get to that, I'll stop once more and ask if there are any questions at this point. I did look at the list of people who are participating, and I know that a lot of you are people who have, I'm sure, done arbitrations and know a lot about it, and are skillful attorneys, and maybe I'm being a little too basic. But arbitration is, I see no questions, so arbitration is like a bench trial. There's an opening, there's a closing, and in between is the evidence. You could present jury instructions or arbiter instructions if you want. Most of us who do arbitrations think that we know the law. Some of us actually do know the law. Some could use a refresher. I always wonder about retired judges, not that I have anything against them, but they have presided over lots of different kinds of cases. And they know a lot about a lot, but maybe they don't know in much depth maybe they don't know in much depth what the substantive law is, or maybe they just think they know. So whereas this is my area of law, so this is what I know about. Somebody asked a question which was, do you get them to pay the low before the hearing? And the answer is sometimes. I mean, you can't force them to, but that's a matter of negotiation. I think some carriers would say it's easier for us from a bookkeeping standpoint to just write a check at the end. And some carriers would say, okay, we can do that. There's no reason why we can't do that. So arbitration is like a trial, and you're going to be paying an arbiter by the hour. And so it is helpful to be organized. It's always helpful to be organized, whether it's a trial before a jury, or trial before a judge, or an arbitration. Page number your exhibits. That may seem very basic, but I read the exhibits that are presented. I tell people at the beginning of an arbitration, my job is to decide the case fairly and impartially based on the evidence and based on the law. Well, in order to decide it fairly based on the evidence, I have to read the evidence. So if you're going to call my attention to a piece of paper in a stack that's, this thick, 150 pages or 250 pages of medical records, and you're going to say on the third page of Dr. Smith's report, and there are no page numbers, and I can't find Dr. Smith's report, I can't follow along with you, and it's not terribly effective. And you're paying me by the hour. So it helps if the records are organized in some fashion so that I can read through them more quickly, and that saves you money on the bill. I didn't mention this, but I have had cases where the defense has agreed to pay the entire charge, the entire costs of the arbitration. It's not a terribly bad idea if you can get the lawyer on the other side and the carrier to do that. It saves you some money. And then you're not under any time pressure. I had one the other day. The hearing took 4.5 hours because we had one of the more loquacious, talkative plaintiffs in the history of jurisprudence. She was asked, where were you sitting in the car? And she said, my husband and I decided to take our friend Rose for a ride. And then she told me about Rose's husband. It was several paragraph answer before she said, in the back seat. So this was a case where the carrier was paying my entire fee. So I guess the plaintiff's lawyer wasn't sweating it that his client was all over the place. So Alan Mensch asks, can you arbitrate with relaxed rules of evidence? Typically we do, like a district court small claims case. District court is a Maryland thing. I don't know if you have that in DC. Most of the time, adjusters and defense attorneys agree. Is it a good idea? Well, you know the case better than I know the case. If relaxed rules of evidence are going to be used, they're going to be used by both sides. And so there may be some reason why you don't want to do it. You're willing to live with strict rules of evidence because you think the defense is not. Your doctor is going to be cooperative. He's going to come. He's going to testify. The defense doctor, she is going to charge $4,000 and not be available. So maybe you don't want relaxed rules of evidence in that case. Like any trial, prepare yourself by reading the medical records. So I said before that you introduce these records, I'm reading them. Every page, every word. I read fast. If your client weighed 180 pounds in the emergency room record, and at the time of discharge, 4 months later, your client weighed 180 pounds according to the doctor, you want to read that. And you don't want your client to testify that as a consequence of the accident, they couldn't exercise and they gained 50 pounds. It's not going to be consistent with the evidence, and I'm not going to be, I'm going to question, well, if they're not being consistent with the evidence there, maybe they're not being consistent with the evidence elsewhere. Prepare the client like you would for a trial. Go over questions you're going to ask, and those that you anticipate will be asked by the other side. I always find it interesting when someone asks a question to the client like, how fast was the other car going? And the client says, I don't know. Well, if the client doesn't know, that's fine. Well, what is the purpose of that question? You would think you would know ahead of time that the client isn't going to be able to answer that question. There's nothing wrong in our jurisprudential system to prepare the client, show the client documents ahead of time, go to the intersection where the accident took place, if that's important, with the client. I think arbiters and jurors and judges are impressed when clients know details. What's on the northeast corner of that intersection? I don't know. What's on the southwest corner of that intersection? Beats me. On the other hand, if the client actually knows the intersection and knows what's on each corner and knows how the accident happened and knows the number of lanes and knows where the traffic signal is and how the traffic signals work, so sometimes that's a good thing. I would recommend, this is not just for arbitration, but for jury trials, bench trials, I would recommend asking questions in plain English. I put in my outline, a good question is, when you got to the emergency room, how did you feel? A bad question is, what complaints, if any, did you relate to the healthcare providers when you arrived at the emergency room? Complaints, to the layperson, complaints means like, you bought a product at Walmart and it didn't work and you got a complaint. They don't understand the word complaint the way physicians and lawyers understand it in terms of a medical complaint. Have your client explain vague answers. So I had a case where the plaintiff's lawyer said, was your car pushed forward as a consequence of the rear end collision? Yes. How far? A long way, or pretty far, said the plaintiff. What does pretty far mean? From here to California, 15 feet. So I interrupted. Arbiters ask questions, just like jurors ask questions. I interrupted and said, when you say you were pushed a good ways, what do you mean by that? And the plaintiff said, at least a couple inches. Famous question. Are you employed? Yes. What do you do? I'm a manager. Get some clarification. I know what a baseball manager does. That's the third reference to baseball today. I know what a baseball manager does, but this guy is a manager, this plaintiff is a manager at the XYZ company. Well, what does a manager do at the XYZ company? I have no idea. Does he manage employees? Does he manage deliveries? Does he sit at a desk? Does he walk the floor? Try to get your client to understand that you're going to need to have the client explain things. Specificity is very useful. I have in my outline, a vague statement is not so great. I couldn't do things with my injured hand. That's a pretty vague statement. I couldn't lift things with my injured hand. That's better. I couldn't lift more than 10 pounds with my injured hand. That's even better. And even better, I couldn't lift the Thanksgiving turkey out of the oven, and I'd nearly dropped it, and so forth. A word about expert opinions and medical reports. Every case seems to have a causal connection sort of letter from a doctor which says, I've reviewed the medical records and it is my opinion that all these injuries are due to the accident. And then there'll be one from a defense lawyer who says sort of the flip side, a defense doctor who says the flip side of that. Me personally, I'm not particularly impressed by conclusory statements. I'd like to know why. Why is it that the plaintiff's doctor says that this rotator cuff injury is from a trivial rear end collision accident for a person who is, here comes fourth reference, a Major League Baseball pitcher and who liked to fish and cast a line for 25 years. He was out there on a boat every day. He played tennis. He used that arm for all sorts of things. And he'd been to the doctor 50 times about shoulder pain. And yet we've got a plaintiff's expert who says, oh, it's all from the accident. I'd like to know why the plaintiff's expert is comfortable making that statement. I know who wrote them the check, but I'd like to know what the medical basis is for that. Or if you have a defense person who says the rotator cuff can't possibly be from this motor vehicle accident, even though you have a 20-year-old plaintiff who's never been to a doctor for the arm, for the shoulder, who doesn't do much in the way of sports, and it's a severe accident. He's driving. It's his left shoulder. He's left-handed. He's clobbered on the driver's door right where he's sitting. What is it about this defense doctor's opinion? What is the basis for him saying this is not from the motor vehicle accident? I know who wrote him the check, but I want to know what's the basis of that opinion. I'd like the medical reports and the testimony of the plaintiff to sort of make some sense internally. I had a case recently where the plaintiff said, when I move my left foot, the right side of my head hurts. I couldn't quite figure out what that was about. She was all over the place. The burden of proof instruction says the person with the burden of proof, that's the plaintiff typically, has to prove with more convincing force that what she says is true rather than not true. Well, how convincing is testimony like that? I move my left foot, my right side of my head hurt. It just medically doesn't work that way. So I would suggest, personally, that you remember that the hearing is about the evidence and not argue outside the evidence. Everything I tell you that irritates me doesn't really affect the verdict because I'm doing it based on the law and the evidence. But I had a defense attorney recently complain about a $70 charge from a doctor's office for a heating pad. And the defense lawyer said, you can go on Walmart and get the same heating pad for $20. Well, I can't go on Walmart. I'm deciding the case based on the evidence and based on the law, based on the evidence that's presented during the trial. I don't go on Walmart after the case is over and find out what heating pads cost. If you want to put into evidence how much heating pads cost, and you're a defense lawyer, you're doing it on relaxed rules of evidence. Get an advertisement from Walmart. Put it into evidence. Then you can argue from the evidence. But don't tell me to go on Walmart. I don't punish a lawyer for making that argument. I don't punish that side and say, well, I'm going to give extra money to the plaintiff because I didn't like that argument. Or when a plaintiff's lawyer makes an argument I don't like, and I'll give you an example in a second, I don't punish the plaintiff's lawyer. I just decide the case based on the facts and based on the evidence. Some things are really good for trial before a jury and not so great, in my opinion, for an arbiter. Let's say you've got a collision and you're arbitrating damages only. The defense is conceding that the accident was the defendant's fault. I don't know what the DC law is, but in Maryland, evidence that the defendant driver was drunk is not admissible once the defense admits liability, because it has nothing to do with damages. So it doesn't matter to me if the defendant was drunk in that situation. And I sort of find it irritating if the plaintiff's lawyer spends a lot of time talking about how drunk the defendant was, because it's a waste of time. I don't punish the plaintiff for that, but I don't see where you get any mileage out of that. I know in DC, per diem arguments are not typically permitted. Is that right, Karen? Yes, no?
I'm unmuting. Yes.
Yes, okay. But they are permitted in Maryland. So you go to the jury in Maryland, and you can say to the jury, my 25-year-old plaintiff has a permanent injury. I think $10 a day for a permanent injury is a reasonable figure. And he's got a life expectancy of 50 years. That's 18,000 more days. So I want $180,000 of non-economic loss. You can do that in Maryland. I don't find that to be particularly persuasive when I'm arbitrating a case. I don't punish anybody for it. If you had a case where the plaintiff didn't have permanency and they treated for 6 weeks and that was it, would you make the same argument? I want $10 a day for 42 days. Give me $420 for non-economic loss. I don't think so. So I'm not personally big on scarring. Maybe that's because I'm not like the most handsome guy in the world, and I got a scar on my knee, and I got a scar up here on my forehead somewheres. But if I have to use a magnifying glass to see the scarring, it's really not worth it. Now, having said that, you have to give your client a chance. I recognize this. This is your client's day in court, and there's a little bit of a balancing act between allowing your client to vent, and the plaintiff, and allowing the plaintiff to discuss that after the accident, the defendant got out of his car and I could tell he was on the telephone. Liability is admitted. Doesn't matter if he's on the telephone or the telegraph. He's admitted liability. But your client wants to tell that story, and I understand that, and that's fine. But and it's a difficult balance between having your client, allowing your client to tell his story, and boring the arbitrator to death with facts that are unimportant. I want to just tell you one thing about Zoom, and that is this. Here we are Zooming. Now, the Supreme Court of the United States is hearing remote arguments. The Court of Appeals of Maryland, that's our highest court, is hearing arguments remotely by some platform like Zoom. I'm not sure if it's Zoom or WebEx or Google something or whatever it may be. I don't understand why litigants say, I don't want to do the arbitration by Zoom. I want to do it in person. We'll wear masks. I think Zoom works perfectly well. I've used WebEx. I think it works perfectly well. And I am going to predict that after we get out from under this pandemic, we will continue to do many of these things by Zoom or WebEx or some other platform. It's so much easier, and it saves lots of time. My office is in Towson, and there's a lawyer from Silver Spring or a lawyer from Upper Marlboro, and they have to drive here. That adds a bunch of time to their schedule. And I suppose if it's a defense lawyer and they're paid by the hour, they don't care. If it's a defense lawyer and their house counsel, they sort of do care. I don't see any reason why these things can't go by remote means. Practice with your client. A lot of these people haven't used Zoom before. Practice a few days ahead of time, practice getting on, muting yourself, everything you need to do on Zoom. It's really not complicated at all. And you can call an expert witness by Zoom if you feel that that's appropriate. And much easier to schedule an expert witness, by the way, live for a Zoom arbitration. You can say to the expert, you're testifying at 10:30. At trial, you don't know how long it's going to take to pick a jury. You don't know, at least in my practice, you don't know when you get there in the morning, the judge says, oh, before we start, I forgot to tell you, I've got a sentencing. It's going to take 3 hours. I went to trial a couple of years ago in Baltimore City, and we were starting the trial on Tuesday, and the judge said, I'm sure the assignment office told you that we would start today, but I wouldn't be available either Wednesday or Thursday, and we'd finish on Friday. Well, no one had told us that. And the defense guy had an expert coming on Wednesday, and he was, he had to move mountains to get the guy available on Friday. But you can call an expert by Zoom. It's much easier. Learn how to use a document by Zoom. You can throw a document up on the screen like the answers to interrogatories of the other side and cross-examine them. You can, of course, provide that to the arbiter ahead of time. I like, personally, to have the documents 48 hours ahead of time. I like that because it focuses me on figuring out what the case is about and what questions I might have. Other arbiters don't like that. They prefer not to get anything until the time of trial. You just have to, figure out what your arbiter is going to do. And with regard to picking an arbiter, that's one of the things you negotiate with the other side. You might have a couple names of arbiters who you think will be fair to you, names that you may have obtained from the DC Trial Lawyers Association or your colleagues, or the Maryland Association of Justice or those colleagues. You may get a name proposed to you by the other side. You may want to run that by colleagues and see, what do you think about Judge Smith or wherever this person may be. You need to worry about who the arbiter is going to be. So Steve Vinnick, my friend, has a question, which is, Does it make a difference to you when you have a live expert witness instead of a report? The only difference it makes really is I can ask a live expert a question. I can't ask that question to a report. I had a 2-day long arbitration in Annapolis. The plaintiff was a very good lawyer, and he called a doctor live. Very difficult causal connection question. And he finished with the doctor, and the defense person cross-examined the doctor. And I just had one question for the doc, which was not in his report, and nobody asked him. And that was, is there anything about this plaintiff which makes her more likely to have sustained this injury from this motor vehicle accident than somebody else? And the doc said, yes, she's really, really, really thin, which she was, and that makes her more susceptible to this injury. Well, that tipped the scale for me, and I, in that case, awarded $1,300,000 to that plaintiff. She had a terrible injury, and she also had an uninsured motorist policy of only $300,000, so she didn't get the $1.3 million that I awarded. That was the last case I had with Nationwide for about 5 years. They weren't pleased, I think, with that award. So, but they've come back and so forth. So I think it's really important to ask your clients, and I think this is true, and I'm just about done. I think this is true at trials, whether it's a bench trial or a jury trial. When they say there are things I can't do that I used to be able to do, it's important for them to make a list ahead of time so they can testify about these things. And I'll just end by telling you this story. I had a case where the plaintiff testified. He had hurt his back, and he lived in a 2-bedroom apartment with his wife. And the question was, are there things you can't do now that you used to be able to do? And he said, yes, my wife and I used to like to rearrange the furniture in the apartment. And I thought to myself, how many ways can you rearrange the furniture in a 2-bedroom apartment? What a ridiculous answer. It's got to be true. Okay, you know, that's like unbelievable. Now, the cross-examination from the defense lawyer was, sir, you know, and many of these cases are already in suit and some are not. This case was. So the defense lawyer said, sir, I have a question about something in your answers to interrogatories. In your answers to interrogatories, you've made a consortium claim, and you've said that before the accident, you and your wife used to have sex 3 times a day. Did you mean 3 times a week? And the guy said, no, I meant 3 times a day. So after the case was over, I went home and I said to my wife, I have an idea. Let's move the furniture around. So again, that testimony was fairly odd, but, you know, kind of had to be true. So know your clients, meet with your clients, enjoy your clients. Work with them ahead of time, get them to elucidate details of how these injuries have affected their lives, and give them a chance to vent. That's fine. And you'll handle these cases in 2 hours or 2.5 hours instead of 2 days. You'll close the file, and in these days, it's the only way to close the file. You can't have a jury trial. And I wish you the best of luck. Are there any other, I did want to just say one quick thing, and that is, with us today is a gentleman named Bob Schwartz, who was a litigant. He lives in California, I guess still lives there. And Bob was a litigant in a case in Prince George's County, got a substantial verdict, represented by Ken Trombley and Dan Singer, and a lawyer from California, whose name I cannot recall. And I was hired after the verdict to do a post-verdict mediation. There was an appeal. So post-verdict, pre-appeal mediation to try to get the case resolved. And had a good time doing that because I do some mediations as well. And it was a very nice to meet Mr. Schwartz. And to help to resolve his case short of having to wait another year, 1.5 years. for the appeals process to go forward. So hello, Bob, and hello to all the lawyers listening who I know, I'm not going to name you all individually. I know lots of you. So thank you very much for listening.
Thank you so much, Irwin. I just wanted to add, if anyone has any other questions in the Q&A box, you can ask any further questions, and anyone else has anything, we can answer those before we leave.
And if you have a question which you'd rather not share with others, but would just like to direct to me directly, one of my handouts has my email address. You can just email me or call me, and I'll be happy to help you out. So, and thank you again to Karen Cohn for arranging today's webinar, and to Mary Zambri for technical assistance and for the fine job she does as the executive director of the DC Trial Lawyers Association.
Well, thank you so much, Karen and Irwin, for this program today. And thank you, everybody, for attending. I also recorded it, so you will be able to refer back whenever you'd like. Okay, so that's it. Thank you, everybody. Have a great day.
Can I tell a joke?
Yes, I liked your other joke about the moving furniture. I'm gonna have to remember that one.
Well, that was actually true. So, but I was, I grew up in Washington, the Washington area. I was born in Washington. I grew up in Silver Spring, and first we lived in Wheaton and so forth. And I was a Washington Senator fan, and I was a Washington Redskin fan. And their name is now apparently going by the boards. And I have a new name for the Washington football team that I will propose. And my proposal is that they be called the Washington Wildebeest. And the reason is, first of all, you get the alliteration thing going. I like that. A wildebeest, also known as a gnu, spelled G-N-U, is a vicious, aggressive animal, and that sort of fits with football. And if there should come a time when people start selling bootlegged sweatshirts and airsats memorabilia for the Washington team, we have a perfect name that comes from Washington for that, and that is fake news. G-N-U-S.
Very good. I like that. I like that.
All right.
Yeah, that was a good one. All right. On that note, we'll end it. Bye, everybody. Take
Bye,
care.
everybody.
Be well.
So long.